Ever notice how ads always pop up at the worst moments? When the killer's identity is about to be revealed. During that perfect meditation flow. On Amazon Music, we believe in keeping you in the moment. That's why we've got millions of ad-free podcast episodes, so you can stay completely immersed in every story, every reveal, every breath. Download the Amazon Music app and start listening to your favorite podcasts ad-free, included with Prime.
Welcome back to The Deep Dive. We are diving into, well, a truly monumental legal fight happening right now at the Supreme Court.
Yeah, it's one that really promises to reshape American political representation, possibly for generations.
We're talking about the Voting Rights Act of 1965, specifically the one major piece of it that's still standing guard against racial discrimination in elections.
That's right. The focus is this pending Supreme Court case, Louisiana v. Callais. And, the signals from the court are, well, they're suggesting it's seriously considering either striking down Section 2 of the VRA or maybe severely reinterpreting it.
And Section 2 is basically the last federal safeguard we have against racial discrimination when states draw political maps or set up local elections.
Pretty much. It's the last line of defense in many ways.
So our deep dive today is really zeroing in on the consequences. What happens if this goes away? We need to understand, the mechanics of Section 2, how it came about, how it's already been weakened.
And critically, what are the precise political, legal, and sort of functional costs if this last safeguard is, gutted?
The stakes sound huge.
They're profoundly consequential. I mean, legal analysis suggests that getting rid of this provision could almost immediately lead to redrawing maps for anywhere from, 6 to maybe 19 congressional seats across the country.
13 seats, just like that, before the 2026 elections.
Potentially, yeah, ahead of the 2026 cycle. And that kind of change, it could easily secure a really decisive, maybe even unchallengeable majority for one party in the House.
Wow. Okay, so to really get a handle on what we might lose, we need to go back to the beginning. Why was the VRA even needed? What was it designed to fix?
Right. It wasn't just about, making voting a bit easier. It was a direct response to nearly a century of institutionalized exclusion, particularly in the Jim Crow South.
A century?
Yeah. The VRA, passed in '65, LBJ called it a triumph for freedom. And it had to be, because it was battling almost 100 years of these mechanisms specifically designed to enforce basically one race rule.
What kind of mechanisms are we talking about?
Oh, layers of them. You had poll taxes, right?
Yeah.
Which were basically economic barriers you had to pay to vote.
Which many black citizens, especially sharecroppers, couldn't afford.
Exactly. Then you had literacy tests. And these weren't fair tests. They were often administered subjectively, specifically to fail black applicants who might be perfectly literate.
And the white-only primary.
That was critical. In many southern states, the Democratic primary was the election. If black citizens couldn't vote in the primary, they had no say, period. It locked them out completely.
It's easy to think of this as ancient history, but one of the sources we looked at really brought it home.
Oh, you mean the story about the guest's great-grandmother?
Yeah. She was already a grandmother herself before the VRA finally gave her the right to register and vote without those barriers.
It's incredibly powerful. It just shows how recent this experiment in, actual multiracial democracy really is, and maybe how fragile.
So the VRA was the tool built to fix that deep exclusion. And the specific part under threat now is Section 2. What's the core of it?
The key text. It prohibits any voting practice or procedure, could be a map, could be a voter ID law, could be an election system imposed by any state that results in denying or abridging the right to vote based on race or color.
Okay, that word, results. That seems absolutely crucial, and it's right at the heart of the current challenge, isn't it? Why focus on the effect or the result instead of just proving, say, racist intent?
Because proving intent is, it's almost impossible in most cases. That distinction, focusing on results, is the entire reason Section 2 actually works, why it has teeth.
Why is intent so hard to prove?
Think about it. How often does a state legislator or a city council member leave a memo saying, my goal here is to draw this map specifically to stop black people from electing their preferred candidate? It just doesn't happen.
Right. People don't usually advertise their discriminatory motives.
Exactly. So if you had to prove that kind of explicit malicious intent, you'd almost never win a case, even if the outcome, the result, was clearly discriminatory.
So if you can't, read the map drawer's mind.
You have to look at the map's function. How does it actually operate on the ground? That's what Section 2, subsection B allows. A violation is established based on the totality of circumstances.
Totality of circumstances. What does that involve?
It means courts look at everything. Are the political processes equally open to participation? Do members of a protected class, Black voters, Latino voters, etc., have less opportunity than other voters to elect representatives of their choice? It lets the court examine the real-world consequences.
But this focus on effect wasn't always the standard, was it? There was a big fight about this, leading to changes in 1982.
That's right. It was solidified by Congress in 1982, directly in response to a Supreme Court decision from 1980 called City of Mobile v. Bolden.
Ah, the Bolden case. Tell us about that. Why was it such a problem?
Bolden is the perfect illustration of why the intent standard just didn't work. Mobile, Alabama used an at-large system for its city commission. Everyone voted for all the commissioners citywide.
Instead of district-based elections.
Right. And this system had been in place since 1911. For nearly 70 years, despite a large Black population, not a single Black candidate had ever been elected to the commission.
70 years of zero representation.
Zero. And the plaintiffs brought forward overwhelming evidence. They showed severe racial polarization in white voters voting for white candidates, Black voters for Black candidates, and a long history of official discrimination in Mobile. The results were undeniable.
So what did the Supreme Court say to that?
The court, in a split decision, essentially shrugged. They acknowledged the outcome, the lack of representation, but they insisted that to prove a violation under the Constitution, the plaintiffs had to show the at-large system was originally conceived or operated as a purposeful device to further racial discrimination back in 1911.
They had to prove the intent from 70 years earlier.
Yes, which is practically impossible. So even with this crystal clear, decades-long pattern of Black voters being shut out, the system was allowed to stand because proving the initial motivation was too high a bar.
That sounds like it makes the right to vote pretty hollow.
It did. Justice Thurgood Marshall wrote a scathing dissent in Bolden. He warned that this standard meant minority citizens only had the right to cast meaningless ballots unless they could somehow dig up proof of intentional bias, which is often hidden by design.
So Congress stepped in.
Yes, Congress saw immediately that basically neutered voting rights protections against these kinds of structural barriers. They acted quickly, passing the 1982 amendments to the VRA, and these amendments explicitly overturned Bolden.
How so?
They wrote the results test directly into Section 2. They made it crystal clear that voters could challenge electoral systems based on their discriminatory effect, regardless of intent. That was the moment Section 2 became the powerful tool it was meant to be, opening the door to challenges against unfair at-large systems and racially gerrymandered maps.
Okay, so 1982 gives us the effects standard. But how do courts actually apply it? How do you prove an effect of vote dilution? That's where the Jingles test comes in, right?
Exactly. Once Congress established the effects standard, the courts needed a framework, a roadmap, for how plaintiffs could prove their votes were being illegally diluted. That framework came from the 1986 Supreme Court case, Thornburg v. Gingles.
And this Jingles test is what's used today.
Yes, it's the mechanism for enforcing Section 2 in vote dilution cases. And it's really important to emphasize, as the sources point out, this test is famously demanding. It is not some kind of guarantee of proportional representation based on race. The VRA explicitly forbids that.
So what does it ask?
It basically asks a series of rigorous questions. Is the system suppressing a minority group that is, 1, large enough and geographically compact enough to potentially form a majority in a reasonably drawn district? 2, are they politically cohesive, meaning they tend to vote together? And 3, does the white majority vote as a bloc strongly enough to usually defeat the minority group's preferred candidate?
Okay, let's break those down. Those are called the 3 Jingles preconditions.
That's right. And plaintiffs have to satisfy all 3 just to get their foot in the door.
So first, large enough and compact enough. What does that mean in practice?
It means you have to show, using demographic data and mapping, that you could actually draw a district where the minority group would be the majority. And that district wouldn't be some bizarre, sprawling shape. It has to be reasonably compact. If the minority population is too spread out, the case fails right there.
So geography is the first hurdle. What about the political behavior parts? Cohesion and block voting.
This is where it gets really technical and often expensive for plaintiffs. For the second prong, you have to prove the minority group votes together. They're politically cohesive. They consistently support the same candidates who are often, though not always, minority candidates themselves.
Okay, they vote as a block.
And then the third prong, You have to prove the flip side, that the majority group, typically white voters, also votes cohesively, but against the minority-preferred candidates, and crucially, that this white bloc voting is strong enough to usually defeat those candidates.
So it's not enough that the minority group votes together. You also have to show they're consistently being outvoted by a unified majority bloc because of race.
Precisely. This requires really sophisticated statistical analysis, often regression analysis, looking at election results over multiple cycles, precinct by precinct. You have to demonstrate what's called legally significant, racially polarized voting.
What if the voting isn't that polarized? Like, if a chunk of the white majority regularly crosses over?
If the analysis shows, say, that 25% or 30% of white voters regularly support the minority-preferred candidate, then the plaintiffs might fail the third prong. The court could say the minority candidate's losses aren't solely due to the white bloc vote, and the Section 2 claim collapses.
Wow. So it really is a high bar, only after meeting all three preconditions.
Then the court looks at the totality of circumstances. Things like a history of official discrimination in the state or county, any lingering effects of that discrimination, how responsive elected officials are to minority community needs.
Like that example from East Ramapo, New York, where the school board moved public comment to 11 p.m.
Exactly. Things like that can be considered after the three Jingles preconditions are met. But you have to clear those first hurdles.
So that's how Section 2 is supposed to function with the Jingles test. But you mentioned earlier that the VRA's defenses have already been eroded. What was the big blow?
The really devastating blow came much more recently, in 2013. That was the Shelby County v. Holder decision.
Right, Shelby County, what did that do?
It effectively eliminated Section 5 of the VRA. Section 5 was the pre-clearance requirement. It was the preventative part of the act.
Pre-clearance, meaning
Jurisdictions, mostly in the South, but some elsewhere, with a proven history of voting discrimination, couldn't change any voting law or procedure, no matter how small, without getting approval first from the federal government, either the Department of Justice or a federal court in D.C.
So they had to ask permission before changing polling places, voter ID laws, or drawing new maps?
Exactly. It was the VRA's first line of defense. It stopped discriminatory changes before they could even take effect and harm voters. Shelby County struck down the formula used to determine which places were covered, rendering Section 5 unusable.
So we went from a system where we tried to stop discrimination before it happened
To a system where discrimination happens, and then voters have to try and fight it in court afterwards, using only Section 2. We went from prevention to reaction.
And what was the immediate impact of losing Section 5?
It was swift and dramatic. Jurisdictions that had been under that federal watch for decades were suddenly free to change their laws however they wanted, immediately. And many did.
You mentioned Pasadena, Texas earlier.
Yes, that's a classic example. Literally, right after the Shelby decision came down, the Pasadena City Council voted to change its election system. They got rid of 2 single-member districts, which had allowed Latino voters to elect candidates of their choice, and replaced them with at-large seats.
Diluting the Latino vote instantly.
Instantly. Because Section 5 was gone, they didn't need permission. And then what happened? It took Latino voters 4 years of expensive, difficult litigation under Section 2 just to get that discriminatory change reversed.
4 years just to get back to where they were before Shelby?
Exactly. It shows the massive burden shifted onto voters and civil rights groups. They now have to constantly monitor for discriminatory changes and then spend years and millions of dollars fighting them after the fact, one by one. Section 2 became the only tool left, and it's a much slower, more resource-intensive one.
Okay, so Section 5 is gone, leaving only the reactive, lawsuit-driven Section 2. And that leads us straight into the core argument in the Louisiana case, right? The argument that fixing discrimination using race is itself discriminatory.
That's the crux of it. The challenge now, pushed by conservative legal activists and states like Louisiana, rests on this idea of a colorblind constitution.
Meaning,
They argue that any use of race in government decision-making, even if it's to remedy proven past or present discrimination, violates the Equal Protection Clause of the 14th Amendment.
so drawing a district specifically to give Black voters an opportunity to elect their chosen candidate, which Section 2 sometimes requires after the Jingles test is met, is, in their view, unconstitutional racial gerrymandering.
That's their argument. It creates this paradox. Historical racism created racially polarized voting and unequal opportunity. Section 2, via Jingles, identifies that problem. But the remedy consciously drawing a district to ensure that opportunity involves considering race. And the challengers say that consideration of race is itself illegal.
It's like saying the medicine is as bad as the disease.
sort of, or that the Constitution forbids using the necessary medicine. Advocates for the VRA push back hard, obviously. They argue you have to be able to consider race to fix a problem caused by racism, especially when you've proven through the rigorous Jingles test that race is the reason a group is being shut out.
They're saying you can't achieve actual equality by pretending race doesn't exist when it clearly drives voting patterns.
Precisely. They argue that a purely colorblind approach in a society still deeply affected by racial inequality just ends up reinforcing the status quo, favoring abstract formal equality. Everyone using the same rules over material fairness, which acknowledges unequal starting points and outcomes require targeted solutions.
Which brings us to Louisiana v. Callais. What are the specific facts there?
Louisiana is almost a textbook Section 2 case. The state's population is roughly one-third black. But the congressional map the legislature drew after the 2020 census, the one used in 2022, only had one majority black district out of 6 total districts.
1 out of 6 when the population is one-third black.
Right. So, black voters sued, arguing this diluted their voting strength in violation of Section 2. They went through the whole Jingles process.
And what did the lower court find?
The federal district court agreed with the plaintiffs. It found they met all the Jingles requirements: large enough and compact population, politically cohesive, faced block voting from the white majority, and that a second majority black district could be drawn reasonably. So the court ordered Louisiana to enact a new map with that second district. That's the 2024 map.
Okay, so the court ordered a fix based on existing law. But that fix is what got sued over.
Exactly. A group of self-described non-African American voters immediately sued, challenging the remedial 2024 map. Their argument was that the legislature, in intentionally creating that second majority black district to comply with the court order in Section 2, had engaged in unconstitutional racial gerrymandering.
They're suing over the cure, basically.
Yeah. And initially, the Supreme Court agreed to hear the case just on that specific question about the remedial map. But then something changed.
What happened?
In June 2025, the court did something unusual. It ordered the case to be re-argued, but on a much, much broader question. They asked the parties to brief and argue whether the intentional creation of a majority-minority district itself violates the 14th or 15th Amendments.
Whoa. So they shifted from, was this specific fix okay, to, is the whole idea of fixing vote dilution this way even constitutional?
Precisely. It was a huge signal that the conservative majority on the court was ready to take aim at the core of Section 2 and the Jingles framework itself.
And this seems like a big shift from just last year. In the Allen v. Milligan case from Alabama, the court upheld Section 2 then, didn't it?
It did, and that's a crucial distinction. In Milligan 2023, the court, including Chief Justice Roberts and Justice Kavanaugh, essentially just applied the existing Jingles test to Alabama's map and found Alabama hadn't shown the lower courts were wrong to order a second black district. Roberts explicitly said he was taking the existing precedent as a given for that decision.
But now in Callais...
Now, they're not just applying the precedent. They're questioning the constitutionality of the precedent itself. They're asking if the 1982 amendment, establishing the effects test and the whole Jingles framework built on it, is fundamentally compatible with Constitution's equal protection principles. It's a direct challenge.
Okay, let's get into the arguments we heard at the Supreme Court in October 2025. What did Louisiana's lawyer argue?
Louisiana Solicitor General Benjamin Aguinaga basically gave the court the argument it seemed to be looking for. He argued that the way courts have interpreted Section 2, primarily through Jingles, has placed states in impossible situations.
How so?
He essentially argued that states are damned if they do, damned if they don't. If they don't consider race enough, they get sued under Section 2 for vote dilution. If they do consider race to draw a Jingles-compliant district, they get sued for racial gerrymandering. His conclusion was stark. Section 2, insofar as it requires race-based redistricting, is unconstitutional. He asked the court to free states from the obligation to create these opportunity districts.
A direct attack on the law's core function. What was the response from the lawyer for the black voters, Janai Nelson?
Nelson pushed back hard on the idea that Section 2 creates an impossible situation. She emphasized repeatedly just how demanding the Jingles test is. She stressed that the need for a race-based remedy isn't just about demographics. It's a direct response to proven, extreme, racially polarized voting.
She cited specific numbers for Louisiana.
Yes. She pointed to evidence showing white bloc voting rates against black-preferred candidates were above 84% in the relevant areas. She argued that when voting is that polarized by race, ignoring race in the remedy just guarantees exclusion. Her warning to the justices was dire. Siding with Louisiana would swallow Section 2 whole and represent a staggering reversal of precedent.
No, there was another key argument, one that came from the Trump administration's lawyer, which seems to offer the court a way out, maybe, this partisanship shield.
Yes, this argument, presented by Hashim Mupan for the administration, is seen by many analysts as potentially the most influential. It offers the court a path to significantly weaken Section 2 without having to explicitly declare it unconstitutional, which could be politically explosive.
Okay, what is the partisanship shield argument?
The core idea is that partisan motivations for drawing district lines should be allowed to trump racial discrimination claims under Section 2.
Wait, how would that work in practice? Let's say a state legislature wants to get rid of a majority black district that reliably elects a Democrat.
Under this theory, the legislature could redraw the map, cracking that black community across several neighboring districts, effectively eliminating their ability to elect their chosen candidate.
Sure.
If challenged under Section 2 for racial vote dilution,
They could just say,
oh, we didn't do that because it was a black district. We did it because it was a Democratic district and we wanted to maximize Republican seats.
and because partisan gerrymandering drawing maps for political advantage is something the Supreme Court has recently said federal courts generally can't police.
Exactly. Since the court has largely washed its hands of purely partisan gerrymandering claims, allowing states to use partisanship as a defense against a racial discrimination claim under Section 2 would create an almost impenetrable shield.
So the state achieves the discriminatory racial effect, the black vote is diluted, but defends it legally using a permissible partisan intent.
Precisely. It would gut the 1982 effects test that Congress fought so hard for. The state wouldn't need to prove its motive wasn't race. It would just need to offer a plausible partisan explanation. This would, as Nelson warned, effectively swallow Section 2 whole while leaving the shell of the Jingles framework formally intact.
Chief Justice Roberts seemed particularly interested in exploring pathways like this during arguments, didn't he?
He did. Roberts has long struggled with the complexities of race and redistricting. He seemed to be actively searching for an argument, and the partisanship shield fits the bill that would allow the court to significantly curtail the VRA's reach while claiming consistency with past rulings, including his own opinion in Milligan just a year prior.
It's a way to weaken the law without the optics of overturning a major civil rights act.
That seems to be the potential appeal for some justices. It achieves the result conservatives want less federal intervention, fewer majority-minority districts, but through a mechanism framed as deference to state legislative prerogatives on partisanship.
And Justice Kavanaugh, he seemed focused on a different angle, the idea of time limits.
Yes, Kavanaugh kept coming back to this idea of an endpoint. He questioned whether race-conscious remedies like Section 2 districts could or should last forever. He acknowledged they might be needed for decades, but seemed to feel they inherently needed a sunset clause.
How did Nelson respond to that?
She argued forcefully that Congress deliberately didn't put a time limit on Section 2 because it's not an affirmative action program designed to expire. It's a fundamental law of non-discrimination. It's meant to operate as long as the underlying problem, racially polarized voting that denies equal opportunity, persists.
So the law itself has a built-in endpoint.
That was her point. She argued Section 2 becomes self-nullifying if and when racial bloc voting patterns fade away. If white voters and minority voters start supporting the same candidates in large enough numbers, then plaintiffs simply won't be able to meet the demanding Jingles preconditions anymore. The third-prong majority bloc voting defeating minority choices would fail.
So the need for the remedy disappears when the discrimination disappears.
Exactly. The law fixes itself when the conditions on the ground change. No artificial time limit needed.
Okay, so we have these arguments. The direct challenge, the partisanship shield, the time limit question. The consensus among most court watchers seems to be that Section 2 is in real jeopardy. So let's pivot squarely to the consequences. If the court does strike down or cripple Section 2, what happens on day one?
Well, the immediate, blunt answer is that the Voting Rights Act, as a functional tool for protecting minority voting rights against dilution, is effectively dead.
Dead. Why so definitive?
Because Section 5, the preventative measure, was already killed by Shelby County. Section 2 is the only significant federal mechanism left that allows voters to challenge discriminatory maps and voting systems based on their racial impact. If you take that away or make it impossible to win under,
There's nothing left.
there's virtually no federal safeguard remaining against systemic racial vote dilution. The VRA, which truly transformed American democracy and ensured non-white citizens could participate fully for decades, would be, as one source put it, pretty much dead. The power shifts almost entirely back to state legislatures, many with long histories of discrimination, with very little federal oversight.
Let's talk specific consequences. First, the political impact in Washington. You mentioned up to 19 House seats potentially flipping. How does that work?
State legislatures in states with significant minority populations and racially polarized voting, think Texas, Georgia, North Carolina, Florida, Louisiana, Alabama, currently draw some districts as majority black or majority Latino because Section 2 requires them to, based on jingles.
They're called VRA districts or opportunity districts.
Right. If the court eliminates that requirement or gives them the partisanship shield defense, those legislatures will be free to immediately redraw the congressional maps.
And how would they redraw them?
They would likely take those existing majority-minority districts, which tend to elect Democrats, especially in the South, and crack them. They'd split those cohesive minority communities up, spreading them across several surrounding districts that are predominantly white and Republican-leaning.
So instead of one district where minority voters have a real chance to elect their candidate, you have those voters spread thinly across 3 or 4 districts where their vote doesn't decide the outcome.
Exactly. It makes those previously competitive or reliably Democratic seats much safer for Republicans. The estimates of 6 to 19 seats flipping are based on identifying current VRA-mandated districts that would likely be dismantled immediately.
And the timing. Before 2026.
Yes, the incentive would be huge for Republican-controlled legislatures to redraw maps before the 2026 midterm elections to lock in a larger, more durable House majority. Given the currently narrow margins in the House, flipping even half a dozen seats this way could guarantee control, potentially leading to what some analysts call effective one-party rule in that chamber for the foreseeable future.
And the impact is geographically concentrated, isn't it?
Heavily. It falls hardest on the Deep South, precisely where the VRA was most needed to overcome generations of disenfranchisement. Think about this. Nearly every single African-American member of Congress currently representing a district in the Deep South, Alabama, Mississippi, Louisiana, Georgia, South Carolina, holds that seat because it's a VRA opportunity district created or protected because of Section 2.
So if Section 2 goes,
those districts likely get dismantled. Those representatives lose their political base, and that hard-won black representation in Congress, built up painstakingly over 60 years, could be drastically reduced almost overnight by the stroke of a legislator's pen drawing new map lines.
That's the impact on Congress. But maybe the more widespread, the less visible consequence is at the state and local level.
Absolutely. This isn't just about Washington, D.C. Gutting Section 2 gives states and local jurisdictions, counties, cities, school boards, basically unfettered ability, as one source said, to redraw their own districts and change their election systems in ways that diminish minority voting strength.
And these are the bodies making decisions that really hit home.
Right. City councils deciding on zoning, police funding, local services, county commissions setting property tax rates, school boards controlling curricula, school funding, disciplinary policies. Section 2 has been crucial in ensuring minority communities have a voice in all of those local decisions.
So losing Section 2 basically gives a green light to return to discriminatory systems that the VRA had forced many places to abandon.
It absolutely creates an incentive to go backwards. Particularly, it encourages a return to using at-large election systems, especially in smaller cities and counties.
Remind us why at-large systems are a problem.
In an at-large system, everyone votes for all the seats on the council or board. If voting is racially polarized, which it often is, a cohesive white majority can sweep every single seat, completely locking out even a substantial minority population. If 40% of your town is black, but they vote differently from the 60% white majority, they get zero representation on a 5-member council elected at large.
And Section 2 litigation forced hundreds of places to move away from at-large systems.
Hundreds, yes. Since the 1982 amendments, countless cities, counties, and school districts switched to single-member districts, where you vote only for the representative from your geographic area, specifically because of Section 2 lawsuits or the threat of them. This allowed minority communities concentrated in certain neighborhoods to finally elect candidates of their choice.
So if Section 2 is gone, they can just switch back to at-large.
They can. And the incentive will be strong for places that want to reduce minority political influence. We need to remember the tangible impact this has. Let's revisit that Farmers Branch, Texas example.
Okay, what happened there?
Before Section 2 forced a change, Farmers Branch, a Dallas suburb with a growing Latino population, had an all-white, at-large city council that was openly hostile to immigrants. They passed ordinances trying to require landlords to verify tenant citizenship, make English the official city language. basically creating a hostile environment.
Government working against a large part of its own population.
Yes. Then, Section 2 litigation forced them to switch to a mix of single-member and at-large seats. And what happened? In 2013, the city elected its first Latina council member from one of the new single-member districts. The whole tenor of city government began to change. Those harsh ordinances faded away.
And without Section 2.
Without Section 2, Farmers Branch could easily go back to the old at-large system, potentially lock out Latino representation again, and those kinds of hostile policies could return. We saw similar dynamics play out in the East Ramapo School District case.
Where the board made it hard for Hasidic Jewish parents to participate.
Right, moving public comments late at night, cutting funding for public schools while favoring private yeshivas. Section 2 litigation forced changes there, too. Or think about Native American voters in places like North Dakota, shut out of county commissions that control services on or near reservations. Section 2 was often their only legal tool to gain a seat at the table.
So the consequence isn't abstract. It's about whether communities get fair funding for schools, whether roads get paved, whether the police are accountable, whether your voice is even heard by your local government.
It's about the fundamental accountability of government to all of its citizens. If a government knows it can safely ignore the needs and votes of a third of its population because they're structurally locked out of electing representatives, it will ignore them.
Which circles back to that philosophical betrayal idea. That gutting Section 2, while racial disparities are still so evident, means prioritizing a kind of abstract, colorblind ideal over actual functioning fairness.
That really is the core tension, isn't it? The court seems potentially poised to say that the principle of formal equality, treating everyone the same under the rules, even if those rules perpetuate inequality inherited from the past, is more constitutionally important than ensuring a genuinely representative democracy where past discrimination doesn't predetermine present outcomes.
And activists warn this kind of erosion of rights never stops with just one group.
Right. The warning is that when you start dismantling protections for the most vulnerable, when you give federal legal approval, an imprimatur, as one source called it, to hostility towards minority political participation, it sets a dangerous precedent. It normalizes the erosion of rights, and historically that erosion rarely stays confined to the initial target.
So wrapping this up, this deep dive really shows that Louisiana v. Callais isn't just some technical case about maps. It's hitting at the very foundation of how we enforce the 15th Amendment's promise against racial discrimination in voting.
Yeah, it's asking whether the tools Congress created to make that promise, real tools that necessarily have to acknowledge race to combat racism's effects, are now themselves seen as unconstitutional.
And the key takeaway for listeners has to be that the significant progress we've made towards a real multiracial democracy since 1965 wasn't inevitable, and it isn't necessarily permanent. It rests heavily on this legal scaffolding, primarily Section 2 now.
And if the Supreme Court decides to tear down that scaffolding, either by striking Section 2 down directly or by crippling it with something like the partisanship shield, well, the whole structure becomes incredibly unstable.
Which leaves us with a really stark, provocative question. If the main federal tool for enforcing the 15th Amendment, the guarantee that your right to vote shall not be denied or abridged on account of race or color, is effectively removed, what does that guarantee even mean anymore?
What power does it have? Is it just words on paper? As Jenai Nelson warned the court, without a tool like Section 2 to enforce it against sophisticated methods of modern vote dilution, that fundamental constitutional right risks being reduced to, in her words, a mere parchment promise. Beautiful, but ultimately powerless.